Okay, good morning, everyone. Friday, February 21st. Continuing testimony on H1 and act relating to accepting and referring complaints by the State Ethics Commission. We have a range of witnesses today. I do have to leave in about 25 minutes for a meeting with the speakers, so I apologize for having to dip out for about 15 minutes, but Vice Chair Hango and Ranking Member Waters Evans will drive the proverbial boat while I'm absent. So with that, I guess we'll get to our first guest. The first person on my list is Will Stevens.
Thank you, Mr. Chair. Good morning, everyone.
How you doing today?
I'm doing great.
Wonderful. I guess we'll do like a quick introductory round robin here. Representative Matt Byron, Chair of the committee. Representative Addison 3, which is Northwest Addison County.
Representative Lisa Hango, representing Franklin 5 on the northwestern border with Canada.
Representative Lucy Boyden, Cambridge and Waterville, Lamoille 3.
Representative Sandy Princeton, Bennington, Rutland 1, Dorset, Danby, Mount Tabor, Land Grove, and Peru.
Representative VL Coffin, Representative Windsor 2, which is Weathersfield, Cavendish, and Baltimore.
Mary Catherine Stone, Burlington.
Jay Hooper, Brookfield, Braintree, Randolph, Danville, and Roxbury.
Kate Nugent of Brookfield.
Hi, I'm Shay Waters Evans from Charlotte and Heinsberg.
Thank you. Nice to meet you all, and I'm glad to be here. Thank you very much for the opportunity. My name is Will Stevens. I'm from Shoreham in Addison County. Greetings from the land of milk and honey. I am a retiring commercial organic vegetable grower. I'm a former legislator. I served in the legislature from 2007 to 2014. I was on the House Ag and Forest Products Committee for a number of years, including as 4 years as the ranking member. I have served the town of Shoreham in a number of capacities over the years, including town moderator, planning commission chair, select board member, other roles as well. And most recently, I've been appointed to the Vermont Ethics Commission. And it's in that, it's in all of those capacities that I sit before you today. I hope you've all received the Ethics Commission letter that we sent earlier this week, in which we asked you to delay immediate action on H1. And I'm here to flesh out some of the thinking behind that request. And I'd like to bring kind of three perspectives to the table. One as a layperson, secondly, as a former legislator, and third, as a new commissioner. And first, as a layperson, I couldn't help but notice that 3 of the 5 House Ethics panel members are 3 of the 4 co-sponsors of the bill, which, as a reminder, proposes to exempt the House and Senate ethics panels from the requirement to consult the executive director of the State Ethics Commission on any complaint referred to the panels by the commission. I find that interesting. Could a layperson see this as a potential conflict of interest and or a scenario that creates preferential treatment for the legislature? Very possibly. I have a problem with this because I believe that for many folks outside of the golden bubble here, trust in government and good governance is low and declining. And I think their perception is their reality, whether we like it or not. Does this bill feed or counter that perception? As a former legislator, I feel the need to point out that the legislature often consults with other branches of government and their representatives in the development of policies, best practices, and priorities. There's no requirement that any resulting legislation reflects any or all aspects of that consultation, but the practice occurs. And to my mind, mirrors the intent behind the statute's language that requires consultation between the 2 bodies. As a newly appointed commissioner, I'm one of 2 non-lawyers on the commission. So far, I've attended only 2 regular monthly meetings and 1 emergency meeting, which is to say that I have a lot to learn and I'm no content expert. So I'm trying to present the high view here and not the granular view. That's your job. And I'm glad that you're in your seats and I'm in my seat at this point. That said, I'm curious to know what's wrong with giving it a year to see how it works. When you put it all together, I have 3 abiding concerns. 1, what are or is the problem or problems that H1 proposes to solve? And a follow on to that question is, does this bill adequately address that problem or those problems? Second, what are the real world consequences, both intended and unintended, that would occur if this legislation passes as proposed? Tied to that question are these. How will it affect the work of the relevant boards and staff who are responsible for carrying out the duties of the legislation? And secondly, how will the public perceive it, i.e. does it pass the straight face or smell test? Third, and perhaps most important, have enough perspectives been solicited and heard from so that the committee can make a solid and informed policy decision? Sticky paper. Simply put, these three considerations were behind my support for signing the Ethics Committee's letter asking you not to rush a vote on H1, and what brings me here today. I'll leave it to the lawyers to present you their views of the prior restraint and constitutionality issues. They'll go granular again, like I say, while I'm trying to keep it upper level here. I'm here to advocate for you to leave plenty of time so that you can listen to, learn from, and have thoughtful deliberations on the variety of perspectives that you could hear from. That way, everyone has a chance to grasp, digest, and contextualize the complexities of this issue. This is the first year of the biennium. The bill's on your wall, and good policy development takes time. That's it. Thank you.
Thank you.
Yeah.
Questions from board members?
Representative Hoover.
How many terms did you serve in the legislature?
4 terms.
And you're sure you'd rather be in that, Steve?
Today, I'm okay with it. Anything else?
Apparently not right now, but yeah.
Yeah, that's fine. Thank you.
If we need to refer to you, we got
I'm
you
here.
over there.
Yeah, thank you.
Thank you.
Okay, up next on my list, I have TJ Jones.
I didn't realize it was on the list for today.
Oh, sorry, TJ.
Oh, TJ, I'm sorry, I misheard you.
Yeah. But I think he was late in getting the Zoom link.
We can-
Okay. Then the next person I have on my list is Director Sibrick.
Okay, well, I was gonna follow up on what TJ said, so I'm not sure if this is the most effective time for me to speak. But I just want to kind of recenter what we're actually talking about here, which is non-binding confidential advice given to the House and Senate ethics panels. I know we also spoke about attorneys and judges last time, and I can touch on that as well, but it doesn't seem like that's the core issue, and they all come back to the same thing. So I'm going to give an overview of the requirement and why we think it's needed. So the purpose of this requirement is just to make sure that the state code of ethics is being applied equally across government and interpreted in the same manner. The reason that we wanted this consultation requirement, and it's important that it's a requirement because it has always been a situation where any of the ethics panels or the professional responsibility board can reach out to us for advice. They have never done so. They refer people to us for advice. The Legislative Council has referred people to us for advice when they don't know the answer to something. And I think that's really important here because we do have people calling us with questions about the state code of ethics. The Legislative Council isn't in a position to answer. And that is what we are talking about here. We are going to be offering our expertise when they are considering, not even just advice-based situations, but complaints. The consequences of those complaints are still up to those panels. No one is judging the qualifications of members here, right? We hear that repeated often when we're talking about the separation of powers issues. Only the legislature can judge the qualifications of its members. That is not at issue here. We're talking about the provision of confidential, non-binding advice, right? What this bill proposes to do is to exempt the legislature from this requirement and exempt portions of the judiciary from this requirement, leaving only the executive branch. The executive branch already voluntarily engages with us. We would have the one branch of government that seeks advice from us on how to apply the state code of ethics to complaints as being the only branch that is required to follow this consultation requirement. And from day one, when it comes to passing ethics laws, the one thing that we have always said is it needs to be applied equally to everyone across all 3 branches of government. We've been offered situations in the past where we could have enforcement powers even over the executive branch if we just leave the other 2 branches alone. That came from a bill that Martin Lalonde sponsored, actually. It didn't make it anywhere, but we said no. We would rather have no enforcement powers than apply to only one branch of government. What we are seeking is a law that applies to everyone, whether you're a judge, whether you're a legislator, or you're an administrative assistant, a security guard, you should all be held to the same standards. That's very important. The one exception to that, and this is for constitutional reasons, is when it comes to the legislature and core legislative functions. Those are already exempt from the state code of ethics. Constitutional issues were addressed when the state code of ethics is passed. We cannot consult, we cannot hear complaints. We do not have anything to do with core legislative functions. And that is something that you can find in case law, you can find in the plain language of the statute. That involves committee assignments, it involves voting. So it involves anything that only a legislator can do and that nobody else can. What we are talking about here when we're talking about providing advice under the state code of ethics, we're talking about only situations where anyone working in state government can do that. Accepting gifts is the key example. I always use the example. Anyone can accept a gift. Anyone can accept a gift in violation of the state code of ethics. Not everyone can vote on an issue related to that gift. So whether somebody can vote on an issue after they've received a gift, that is always going to be up to the legislature to determine. We do not even advise on that. We can only advise on whether that gift was accepted in violation of the state code of ethics. That is the distinction. That is a constitutional distinction that already exists. Okay. So moving on, I just want to say, if these are truly constitutional concerns, they are very easily fixed. So with minor language changes, and when I say fixed, I mean clarifications that clarify a situation that already exists. So threshold issue that I don't think has been discussed enough. It was addressed when the Ethics Commission was set up in the way that the Ethics Commission was set up, but has not been addressed since then. The Ethics Commission is within the executive branch. It is not of the executive branch. We do not have executive power. We do not wield executive power. We are set up in the executive branch for administrative purposes only. That is different for constitutional purposes. The governor does not oversee us. No one in the executive branch directs our work. They don't have hiring power. They don't have firing power. We basically get IT services. We use them for payroll services. This is the common way that ethics commissions are set up across the country. And the reason that they are set up this way is because of constitutional separation of powers issues. So we are already set up for administrative purposes only within the executive branch. We are not of the executive branch. So when you say like the executive branch is wielding this power, they can't wield this power over the judiciary or the legislature, that is not what is happening here. And what you can do very easily to clarify this, again, you're clarifying a situation that already exists, is you can just say the Ethics Commission is an independent agency. So it was already set up, the words are there. We're independent within the executive branch, but not of the executive branch. That will solve all of these problems. 4 words, nothing else is needed. All right. So TJ is going to talk a little bit about this, and we're talking about, prior restraints. He'll talk about how the prior restraint doctrine, which we discussed last time, that applies to First Amendment issues. It applies when you're talking about the government vis-a-vis the public. It is not when you're talking about the government and the government. So he'll explain all of that. So the constitutional issues when it comes to the 60-day consultation, requirement, again, just practically speaking, that is the time limit. It is not how long the consultation, takes. So, and it was put in that, the 60-day window was just put in there to make sure that there was a time limit so things didn't stretch out too long. And the benefit is supposed to be going to the investigating entity. So they have time to receive the complaint, review it, look for additional facts, then come back to ask us for advice. But this can be dealt with very practically speaking. So the receiving entity, the entity that is going to receive the complaint, can just say, we're going to set the date when we are going to close out this complaint. The Ethics Commission has to provide their consultation prior to that date. The end. We have no control over the time limit. The receiving entity, for whoever's receiving the complaints, they tell us what the date is. We meet that date. And I'll say that in my experience, we get complaints out quickly, like within 2 or 3 days. When we get closure letters back, it takes weeks to months. So I really don't think we are the people, we're not the ones in the position who are going to be slowing this process down, and we're willing to meet as long as there's a reasonable time frame. I mean, if you say we're going to close it out in an hour, that's not a reasonable time frame. If you say like, okay, it's the 11th, we're going to try to keep it in the 18th, we're going to get you our advice by then. I'm going to very quickly just review the arguments that were made by the judiciary because they came up repeatedly when we talked about the state code of ethics. The judiciary did not want the state code of ethics to apply to certain members of the judiciary. What we heard last time was discussion about the rules of professional responsibility, the rules of judicial conduct. When it comes to judges, I won't talk about that right now. I'll just point out that judges were not initially conceived as being part of the state code of ethics. That was not a part of the initial draft. It was the legislature that independently decided to include them. They said judges should not be treated differently from anyone else when it comes to state code of ethics. That was the Government Operations Committee that made those decisions. That didn't come from us. That was a legislative decision. When it comes to talking about the rules of professional responsibility for lawyers, we always hear a lot about, the judiciary, the Professional Responsibility Board has sole authority to discipline its members. That is when we are talking about attorney functions. That is when we were talking about license. That is when we were licensing. That is not when we were talking about any behavior that an attorney engages in. So we have very clear real life examples of this. So say an attorney works for a private employer, they're caught stealing $500 from a coworker. You don't go to the professional responsibility board. Somebody could report them later because it could impact their license. The professional responsibility board should say, maybe we should consider whether this person should be attorney. But for that private employer, they're going to fire that person. They might report them to the police. The police can investigate that. They can charge them with a crime. There's not an exclusive disciplinary authority when it comes to all behavior of a person just because they're an attorney. Professional responsibility board deals with licensing. This is common. This is common. If Vermont were to make an exception for an attorney when it comes to any kind of exemption under state code of ethics, we'd be the only state in the country that did it. We would be a laughingstock for doing it. This came up repeatedly during the discussion of the state code of ethics. It's very clear that attorneys, anyone, can be subject to multiple, codes of conduct. You have a private employer code of conduct, you have the state code of conduct. In fact, that exists now. So if you work in the executive branch, you're an attorney, you're subject to PRB rules and, personnel policy, personnel procedures, DHR's personality. Sorry, I was going to try to thought. You're subject to DHR's code of conduct in addition to licensing rules. I used to work for the federal government, subject to licensing rules and the federal code of ethics. That's just normal. Some things fall under the code of ethics, some things fall under professional responsibility board. But I just want to bring that up because I did not hear that distinction being made, that they're very much two separate things. So, DHR can't take away your license as an attorney, and PRB can't take away your job in the executive branch. That's what we're talking about. That's the difference that we're talking about. So in sum, I can answer questions later and let other people go because I know that there are many people, but I just, we're talking about the rush to get this done. There are some pretty serious issues that we're talking about here. So although it seems like we're talking about something very narrow, this consultation requirement, there's much greater implications. And so since we've been working on ethics, there has always been a desire to see the code of ethics, to see enforcement powers, to see any kind of powers the ethics commission has applied only to the executive branch. The decision was made not to do that. And so it's really hard to see how this is not kind of a continuation of the argument that people who did not want to see the code of ethics applied uniformly, they don't want to see uniform enforcement powers. It's really hard to not see this as a step in that direction, as a first step into rolling back the ethics commission's powers until we get to a place where we only have any kind of authority over the executive branch. And I will say that even when we're talking about the code of ethics now applying to everyone, we have not seen evidence that all three branches of government are equally attempting to familiarize themselves with the code of ethics and how to apply it, or even evidence that they're actually applying it. I see evidence that people are really relying back on their codes of conduct that already existed, and the code of ethics not being something that's integrated into their thinking when it comes to how they handle employee issues.
Any questions for Director Sibrick?
I have some.
Okay.
I wanted to first clarify, so when we first heard the bill introduction from Chair Lalonde a couple weeks ago, it was January 23rd, I think. He said that the ethics panel has to wait 60 days. And that's kind of the crux of the issue, right? Is that 60 days? But I wanted to clarify, nobody has to wait 60 days. Is that correct?
You can ask us for advice whenever you want. So there was no time limit for the ethics commission to respond. And just to be honest, because it's never really an issue for us, we do it relatively quickly. But you could just, if you're worried that the ethics commission one day might take 60 days, you can just, like I said, change the language. The receiving entity will let the give the ethics commission a reasonable time frame. I mean, we can talk about the specific language at which they had to provide the consultation to make sure it doesn't interfere with their operations.
Yeah. Sorry. So my follow-up would be, what if there was just no comment? What if it just said the consultation shall be in writing?
I think you said, when you say the consultation should be in writing, so we already have the requirement in there that happens before the case is closed out, so that the advice has value. Because we don't want to set up a situation where we're only providing advice after the fact. Maybe it's happening a year after the fact where there's no timeline, because what we want to be able to do is explain the state code of ethics, how we see it applied in the situation. So I'll give you an example that has come up more than once when it comes to legislators. They call us and say, I want to make a recommendation for someone. Can I do it on letterhead, legislative letterhead with my title? So then we talk through the scenarios, and they've told us, we've been cleared on the legislative side, but it's been suggested we also ask you, Well, no, if this is a personal recommendation, you just know somebody in a personal manner. If you do that in legislative letterhead and use your title, then you're giving the impression that this is, you know, an official action, that the, you know, the legislature as a body supports this recommendation. So these are just the nuances. I mean, it's a very minor example, but these are the nuances. We're going to be able to think about it from all the different angles where the legislature has not been set up to, you know, work with the code of ethics yet. So what we want to be able to do is provide the advice before major decisions are made on a complaint. And then it's up to the House and Senate ethics panels what to do with that advice. We don't even have to know what they do. They don't even have to tell us like exactly how they resolve a complaint. They can just say, we made findings, we didn't make findings, we closed out the complaint, XYZ. No one has ever provided us with a very detailed report about how they handle the complaints. They just say, we met on this date, we did this, we closed the complaint. It's just a matter of hearing the advice.
And then I also was wondering, I mean, it seems like the trampling of the Constitution is what we're really talking about right now. I'm wondering if you can briefly touch on the process that went into creating this law in the first place. It seems like such a glaring error would have been caught at some point previously. I just wanted, if you could tell us how this was created, because it seems unlikely to me that such a huge constitutional violation would be like entirely missed in the bill creation process and then as it went through the House and Senate.
Yeah, and so yes, that is true. And again, you know, it kind of goes back to we start with the adoption of the state code of ethics. All these constitutional issues were discussed. So there's a big fight over adopting the state code of ethics. It was all about enforcement powers. It wasn't about the actual, state code of ethics itself. And so the issue was people knew once that was passed, the next, we're going to be moving out from there. So the constitutional concerns were baked into the state code of ethics already by exempting core legislative functions. When it comes to the bill last year, there are 3 major sections in the bill: municipal ethics, financial disclosures, and investigatory and hearing powers for the commission. So what was really examined there was the investigatory and hearing powers for the commission. The commission has that, right? We do have the power to investigate and hold hearings over anyone in state government, with the exception of core legislative functions. That did not pass accidentally. That did not happen without anybody noticing it. That was something that was discussed. And I do know that Legislative Council at the time looked into those issues very seriously. But we did talk about the makeup of the commission because we do not have a governor's appointee on the commission, right? And so when it comes to enforcement powers, you do need to have someone appointed by, we had no one from any branch of the government making appointments other than Chief Justice, which is frankly pretty unusual. So we discussed it, they looked at it, we researched it. Everyone was very clear that as long as the Ethics Commission wasn't, enforcing the law, then it didn't matter that the governor didn't have an appointee, that our current setup, which was basically only community groups at that point were appointed to the commission, that everything was okay. So everything was okay that was in the bill last year constitutionally up to the point of actual enforcement. And we do not have actual enforcement in the bill. So that was the result. Yes, everything has been cleared constitutionally. When you get to the point where we're discussing enforcement powers, then you'd have to talk about the makeup of the commission and whether it's sufficient in terms of, having enough government appointees on the commission. But this was something that Legislative Council looked into, that we looked into our end, that we had discussions about as well. So
this issue did come up. It was decided that the constraint was going to be a problem constitutionally.
Yeah.
Okay.
Anything short of actual enforcement was fine.
Yeah, for now.
Representative Nugent?
It's not really as much of a question. It's just, I think that even if it was looked at before, the fact that it's still an ongoing discussion, to me indicates that there's still something to discuss there. So I think it's important to flesh that out, even if you have a strong opinion one way or the other.
Yeah, I mean, I think what we'd like to be able to do here is just kind of resolve these issues for all, because they do come up over and over again. And I will say they get resolved and they come up over and over again. And where we see this coming from is that, certain parties just don't want to see the Ethics Commission have oversight. And that's what it comes down to. And so we see these issues come up over and over again, but it gets to the point where the Constitution is being used as an excuse to shield people from oversight. And the constitutional concerns, they're repetitive and they get knocked back every single time. And our solution here is just make it very clear that the Ethics Commission is of is not of the executive branch. It's within the executive branch, but it's not of the executive branch. And TJ, when he's here, he can give you, he's here, okay. Well, when he talks, I probably covered a lot of, his ground, but he can answer these questions, more readily than I can because he's an expert in national practices, but this is how other states handle it. We're not reinventing the wheel here. The separation of powers issues are not unique to Vermont. We are behind when it comes to ethics, so we can benefit from the way that other states have resolved these issues. And the way other states have resolved these issues is to set up the Ethics Commission in a branch of government and make it clear that they are not of that branch of government. They do not wield the power of that branch of government. They're only there for administrative purposes.
Like clarifying, perhaps you don't want to, but when you say certain parties don't want this to proceed, or could you be more specific or clarify what you mean by certain parties?
I mean, well, I don't want to give specific names.
No, I didn't mean specific thing. We don't need to do that. I just maybe generally.
Generally, the judiciary has always come out against anything that involved the equal application of like the state ethics laws to include the judiciary. So initially, it was even the application of the state code of ethics to judicial branch employees at any of them. Then it became narrowed down. The conversation really revolved around attorneys, and like I said, there's a big distinction when it comes to attorneys. So we're talking about the exclusive authority to regulate attorneys in the practice of law versus in all other situations. You don't work for Casella Waste Management, and then if you harass your coworker, they can fire you. They don't have to call the professional responsibility board and say, "Hey, we're willing to fire this person. Can you do it for us?" Right? That would be a situation where the professional responsibility board had exclusive powers over attorneys, and that's not the case. You join the military, you don't go say, "Hey, I'm an attorney. I'm not going to follow the military's code of conduct. I have my own lawyer." Right? That would be absurd. So that's what we're talking about there. And so this strain of argument keeps coming up, but that one's a very clear one, an easy one to knock back, but it keeps coming up, right? And so the question is why? And I think the answer is because people just don't want the oversight. It's new for Vermont. We are behind, and people are used to doing things the way they're used to doing them. And so change is difficult, right? We see that with the municipal code of ethics. We got a number of calls and we're like, wow, this is a long time coming. But then of course, the reason it was a long time coming is because there are people who just didn't want to see change, and change is hard. But I don't think you can really argue that the Ethics Commission has done anything. We haven't crossed any lines. We haven't become like, a tool of politics that people feared. Like, we primarily give people advice and we help them comply with the law. And that's what this consultation requirement is about, to continue helping people comply with the law. And where we haven't seen engagement, trying to create that engagement. Because like I said, we do have investigatory powers, right? So this is a way that receiving entities that investigate complaints can maintain their total control over the complaint, right? They just take our advice and then they handle it how they're going to handle it. But the way things are now, and this was a decision that was made, a clear-eyed decision was made to give us investigatory powers over the 3 branches of government last session. You can't argue that, right? It would be a major, major thing to try and roll that back now. And so this is a way for us to aid the referring entities and how they're handling those complaints while they still get to maintain control over those complaints, but they are getting independent advice from experts on how to apply the law.
If no one else has any questions, we do have one time constraint, and I'm going to look to our witness, Attorney O'Grady. Do you want to go now?
Sure.
And then we'll call on TJ right after. It's okay with you. Our attorney does need to leave in another meeting.
Good morning. My name is Mike O'Grady with the Legislative Council. I've been with Legislative Council for over 20 years. And for many of those years, I've been responsible for advocating to maintain the authority of the legislature that's granted by the Constitution. When I was first faced with one of those issues, it was like 2005. And the executive branch and the attorney general was not recognizing a clearly recognized legislative authority. And I went to the then director at that time, Bill Russell, and I said, what do I do about this? He said, well, why don't you call some other legislative councils around the country? And I did. I called no, I won't use their names, but I called one from Florida, I called one from Minnesota. And the gentleman from Florida had just finished litigating a case in front of the Supreme Court in Florida, protecting the legislative authority because the Florida Attorney General wouldn't represent the legislature in that case. Then I talked to Minnesota, and the legislative director there said, you're going to have to fight your Attorney General. You're going to have to fight your executive branch to maintain the legislative authority that's granted to you in your Constitution. Because they don't understand your authority. They don't respect it. They want to reach in to how the legislature operates, and you have to push back. And over time, we have done that, and we have been successful. We've had the political question doctrine recognized by the courts. We've had the sole authority of the legislature to judge the qualifications of its members recognized by the Vermont Supreme Court. We have the federal court recognize the legislative privilege for Vermont legislators and staff. We had state court recognize the legislative privilege for Vermont legislators and staff. And we did that often over the objection of the Attorney General, and usually over the objection of the executive branch. I'm here again to maintain or advocate for you to maintain your legislative authority. As the Supreme Court has said, the Vermont Supreme Court, not Supreme Courts in other states, and not the Supreme Court of the United States, the Vermont Supreme Court has said that you have sole legislative authority. That means you alone have legislative authority regarding qualifications of your member. And the state code of ethics recognizes that. That is what I'm here to advocate for. As to whether or not there will be consistency with the state code of ethics, I just said the state code of ethics says that the legislature will be treated differently. So there will be no consistency. There never will be uniform consistency because, for instance, the legislative standard for conflict of interest is different from the state code of ethics, and it likely always will be. Because you couldn't operate underneath the state code of ethics conflict of interest standard. You just couldn't. As to whether or not the judiciary will operate under the state code of ethics, well, I think you heard Merrill Bent say the other day that they likely won't. So there won't be consistency with that either. For those issues that are outside the qualifications of the members, yes, the House Ethics Panel does recommend members go to the State Ethics Commission for questions such as gifts, because that is not part of the core legislative function. So the panel already refers those questions that it receives, or really it recommends that legislators take their questions to the panel. And that will continue, those things that are outside the legislative function. So maybe there will be consistency with that regard, but not for core legislative function. There won't be consistency because it's the sole constitutional authority of a legislature to judge the qualifications of its members. As to why it says what it says it shall consult, and why wasn't that identified? And legislative counsel previously said it was okay. You make errors all the time. You do. And you fix them. You actually have a bill, technical corrections bill, every year. It's pages long, sometimes hundreds of pages long. You made an error. You're fixing an error. It happens. As to everyone was consulted and the constitutional issues were resolved, all other states address these constitutional issues differently? I don't know that. I haven't looked at all other states because I don't care about all other states. I'm looking at Vermont Supreme Court, the Vermont Constitution, and how it's implemented and administered in Vermont. And again, the Vermont Supreme Court says the legislature has sole authority to regulate the functions and qualifications of its members. Requiring the legislature, and it's a mandate, it says shall consult makes that process no longer a sole authority process. 60 days, 5 days, now we're hearing 2 to 3 days. It's a shall consult, it's a mandate on allowing an executive branch agency that's not an executive branch agency to interject itself to try to get consistency for something it's never going to get consistency for. So everyone has been referring to H1. That is not the current proposal of the House Ethics Panel. The current proposal of the House Ethics Panel is to retain consultation with the State Ethics Commission, but to have that consultation or recommendation or whatever you would like to call it to be made when the complaint is referred. If the commission can literally respond to a request within 2 to 3 days, why can't the commission provide its recommendation when it refers the complaint? I don't see a distinction. And there's still some recommendation to find consistency for something that there's never going to be consistency. And in my opinion, that fixes the issue of the legislature retaining its sole authority to judge the qualifications of its members. I'm going to skip over the whole separation of powers argument. I could go into that, but I honestly don't have the time. So I'll just go back to, we've been advocating for the legislative authority and maintaining the legislative authority consistent with the Vermont Supreme Court's construction of the Vermont Constitution. We've been doing it for 21 years or more. We've done it largely over the objections of the executive branch, but largely consistent with the judiciary's interpretation. We will continue to do that in our office. And what we are proposing from the House Ethics Panel would maintain that while also allowing for the State Ethics Commission to provide its recommendation on application.
Can I just clarify that the proposal on the table now is from an H1 amendment, February 10th? Does that sound like correct?
Yeah, I think I've confirmed cable yes, it is. Not cable, I'm sorry.
I just posted it in today's documents. Thank you very much. Any questions for Council O'Grady? Dr. Nugent?
Thank you. I was just wondering if you could explain a little bit the risks to legislative authority by going this route, and also the connection to the separation of powers if it doesn't take it.
Sure. Well, the risk is that, or let's use the conflict of interest standard as an example. And I don't have the state code of ethics conflict of interest in front of me right now. But the conflict of interest standard for legislators is largely different. And you get to vote on things where you have an interest, you might have an interest. You're all gonna vote on education property tax reform. Many of you own property. Some of you are teachers. It's gonna affect your health care. Some of you are lawyers that vote on criminal provisions every year. Some of you are farmers that vote on farming and voted on farming all the time. In certain situations under the state code of ethics, conflict of interest, and I don't have it in front of me right now, those might be considered conflicts and you would be in violation. But in the legislature, you were voted in, you were elected, you ran to represent the interest of your constituents. And you and your constituents often share interests. And unless you have a very particularized personal or pecuniary interest, you get to vote. In fact, you are required to vote because you are required to represent your citizens, your constituents. And if you don't vote, you're robbing them of representation. You're never going to get that conflict of interest standard from the state code of ethics applied to the legislature. It's never going to happen because it would paralyze you.
Lawrence Evans.
Can you briefly touch on what would happen if we didn't? Let's just say we decided to sit on this and then someone made a complaint, then what would the next?
That's really interesting. I don't know. I mean, you have options. Let's go back to the separation of powers question. One of the things that executive branch agencies, like, it always like implodes their brain is like legislative rules take precedent over statute. So the legislature has the ability to adopt a rule that's in conflict with this statute, and that legislative rule would control regarding the qualifications of its members. You don't need to do this in statute. You could do this in rule. You're doing it in statute to be transparent about your concerns and about what you think is an error that needs to be fixed. You don't need to. You can just do this by House resolution. Your House Rules Committee is 5 people. You pretty much pass any rule that comes out of House Rules Committee. But that's not what you're doing. And then there's also the question of who is going to enforce this? Is there going to be compliance by anyone, not just the legislature, but anyone that's subject to this? I don't see how this gets enforced. And that would have been something I would have said when or if I was consulted. The House Ethics Panel and Betsy Ann and my staffing of the House Ethics Panel has predated the existence of the State Ethics Commission. We weren't consulted. The House Ethics Panel wasn't consulted. Nobody talked to us. I don't consider myself an expert on ethics. I would never call myself an expert about anything. I remember my father was an expert on some issue of accounting and he forgot he was an expert. But we've been doing this a long time. And if we had been consulted, we probably would have advised something different. But we weren't consulted, and that happens, man. That happens. This is a legislative process that is not always clean, not always pretty. It happens. Errors get made, and you fix errors. Fix errors every year.
Any additional Questions, comments? Thank you very much for your time. Appreciate, we also appreciate the other witnesses letting us shift the order a little bit.
No,
I do need to leave, if that's okay.
no, yeah, no,
Thank you.
understandable, Council. Thank you for finding the time this morning. Okay, so we are gonna get back to one of our earlier witnesses on the lineup who seems to have joined us online, TJ.
Thank you. I apologize for my tardiness. I've had the pleasure of meeting a lot of you before, both last session and the session before, in discussing ethics. For those of you who don't know me, my name's Thomas Jones. I teach governmental ethics and accountability at the University of Connecticut. Previous to that, I was a member of the Connecticut State Ethics Board. I was formerly the executive director of the California Fair Political Practices Commission. And prior to that, I was the first ethics enforcement officer in the state of Connecticut. And it's been a privilege over the last several years to help the Vermont State Ethics Commission try to navigate some of these hurdles because as you've heard, a lot of these hurdles have come up in other states, and Vermont has had the opportunity to stand on the shoulders of giants of other states that have been able to navigate these previously. I wanted to first, I do want to address the constitutional issues that were raised on February 13th. I wasn't able to be there, but I have reviewed the tape. But prior to that, I think it's important to dispel what seems to be a misunderstanding. The Code of Ethics right now, and in addition, this provision has built in the separation and the primary function of the legislature in judging its own membership. By design, the code already says that anything that has to do with the legislator's core function or legislative function is not a part of the Code of Ethics. The Ethics Commission has no authority, no jurisdiction for anything that falls under the legislature's core authority. So a conflict of interest that may arise under your rules for voting or decision-making has nothing to do with the Code of Ethics. If a complaint were to be received as to some legislator voting on education or farming or some of the other examples that were brought up, that complaint likely would not even be forwarded because it doesn't trigger the Code of Ethics. Those core legislative functions have nothing to do with and do not fall under the Code of Ethics right now. The Code of Ethics speaks to everybody for those things that fall outside of core legislative functions. By way of example, if a legislator was to, and believe me, I know this has not happened in the state of Connecticut and in the state of Vermont, but it has happened elsewhere. If a legislator were to call up a lobbyist and say, I think I can get your son or daughter a job with the legislature, but you need to give my son or daughter a job, a high-paying one, at your business. That doesn't trigger the core legislative function. It's not talking about legislative decision-making. It's not talking about legislative conflicts of interest or voting. It's something that falls outside the duties of a legislator. And that would fall under the code, just as it would for anybody in the executive branch, anybody in the judicial branch. It's a conflict that falls outside of what your duties are as working for the state of Vermont. So there may be, the concern would be that this is all a discussion about something that doesn't exist. And that brings me back to the most important thing for codes of ethics. It doesn't matter where it is, but one of the most important things is consistency and predictability. People want to know what the rules are. Almost everybody shows up for work in the government every day trying to get things right. And that's why the State Ethics Commission is there. The legislature provided them with an advice function, an education function, and the goal is to have everybody singing off the same page. Everybody wants to have the exact same idea of what's right and wrong, because nobody wants to accidentally trigger any accusations that they are somehow violating the code of ethics. It's very difficult to have that consistency and predictability if different people are having different interpretations. And it is a good idea for the Ethics Commission, as it does, when it receives a complaint and refers it along, to say this is what we see within the complaint. But you know, complaints don't come in fully fleshed out. Complaints get received and they have a life of their own, an investigation of their own. Things come up, other things get discovered, and quite frequently allegations in the complaint aren't exactly what they turn out to be in real life. And it's that situation that Section 1223 tries to deal with, is to try and make sure that as the process goes through, that there's a common understanding of what the code of ethics means and what each of the rules means. And this is typical in other states. Vermont's its own state. It has its own rules. But there are similarities into how you want an ethics commission to behave. And again, that consistency and predictability is a very important part of it. I do want to address a couple of the constitutional questions that arose previously, but if anybody has any questions about what I've already said, I'd be happy to take them.
Any questions from the committee? No, yeah, please proceed.
I'll be very brief. Separation of powers is always important. That's why it's come up every session now. This committee, and I can't remember whether it was last session or the session before, but we did hear from Betsy Enrask with respect to the separation of powers issues. And the commission itself has been desirous of navigating around those as much as it understands them. The commission has no interest in getting into a constitutional fight. That's not their mission. Their mission is good government. In terms of the separation of powers, as a threshold matter, the commission is in the executive branch for administrative purposes only. It has no executive branch authority. The governor doesn't have any appointment authority for the commission. And again, this was all by design, that there is a concern that you don't want even the appearance that one branch is usurping the power of another branch. This current requirement that's under discussion is a procedural requirement. It's not a substantive requirement. There's no obligation for the legislature to make any decision in any particular way. Its goal is to drive a discussion, a continuing discussion about what ethics means and what the code of ethics means. But this model of being in the executive branch for administrative purposes only is the model for a majority of the states that have commissions. They've designed their commissions that way in order to avoid the separation of powers issues. And I can't stress this enough. The commission itself wields no executive authority. The governor cannot speak to the legislature through the Ethics Commission. It has no appointment authority. The governor can't direct the Ethics Commission to do anything. So this idea that there's somehow a battle between the constitutional authorities simply isn't there. And in addition, what we're talking about here is a procedural requirement. You need to talk to each other to make sure that you get the law right with respect to the code of ethics. I also heard from February 13th the idea that this was somehow prior restraint. That's a misapplication of the doctrine. Prior restraint has nothing to do with government-to-government interaction. It has to do with the government trying to restrain a private citizen's speech. It's not applicable to government action in any state or the federal government. The other idea was that this might raise what's called the political question doctrine. And the political question doctrine is when two branches have a disagreement about a constitutional function, whether the court should intervene or not. And the political question doctrine says that when the legislative and the executive branch have disagreements about what their obligations are, the judicial branch will step aside and let them figure it out as much as possible. Again, that's not happening here. Really what this is, and I'll get back to where I started, it's a goal to make sure that everybody has a consistent and predictable understanding about what the rules are. And the opportunity here is to have people learn as we move forward in trying to figure out where the specific lines are with regard to ethics. That can only happen with a continuing dialogue between the commission and those who are subject to the code of ethics. I hope this makes sense and is helpful in some way. And again, I'm happy to take any questions that the committee has. I did not submit written remarks in advance, and I apologize for that. But I will submit these written comments after the meeting.
Okay. Yeah, no, that would be helpful. Any questions for this? All right. Don't appear to at the moment. No, thank you for your time, sir.
Thank you very much.
Yeah. Looks like we have what's next.
Hi,
Hi, Dottie.
my name is Dottie Ricks. But first I would like to say thank you so much for taking the time and making the effort to listen to folks like me and groups like the Vermont League of Women Voters whom I represent. I can't imagine sitting here and listening all day to all of this, and you have my deep gratitude, both from the League and as an individual Vermonter. I'm here today as a representative of the Vermont League of Women Voters. As set forth in a previous letter to this committee from the League, we oppose the passage of H1. We oppose the passage of H1. This bill does not seem to advance knowledge and transparency. It will prevent consultation between legislative ethics panels and the State Ethics Commission on complaints directed to the panels by the commission. Consultation can only increase knowledge and understanding of the ethical issues presented. A lack of consultation can lead to hasty and possibly flawed decisions. Incomplete information is not in the interest of public disclosure. The public has a right to accurate, thoroughly examined, informed, and thoughtful decisions, and we hold those expectations of you as our representatives. The League is concerned that H1 is being expedited through the legislative process without adequate deliberation. We oppose fast-tracking H1. Again, we oppose fast-tracking H1. Fast-tracking a bill that evades thorough consultation and consideration does not lead to good law or good policy. On the contrary, it serves neither the public interest nor the legislators who would benefit from the input of the Ethics Commission. The league has advocated for a strong state ethics commission since before the establishment of the commission in 2017. Then in 2017, we were instrumental in helping pass that legislation that established the commission. While the commission was a step forward in protecting the people of Vermont from unethical actions by politicians, it still lacked a state code of ethics and investigative and enforcement powers. We supported the establishment of such a code in 2022. We are proud of how far Vermont has come in promoting governmental ethics and of our role in that process. And if you Google the question, what states are the most progressive in ethics commissions, Vermont comes up, not because, I guess, of how good it is, but that we are moving forward. And I'm very proud of that personally. H1, however, appears to be a regression in that process, moving us backward instead of forward. The people of Vermont deserve greater transparency in government, which in turn promotes trust in government. We are a state that has been first in many actions. The first to ban slavery in 1777, and the first to legalize gay marriage in 2009. For a state with such forward-looking people, we have lagged sorely behind other states when it comes to ethics, accountability, and a process for determining that. Please reject H1. And it is not in the interest of the people you serve. This is a bill that would certainly have little, if no public support, if people were aware of it. The League of Women Voters of Vermont wants and has always advocated for an effective, strong ethics commission for Vermont. H1 undermines the Ethics Commission rather than strengthens it. For those reasons, the League of Women Voters of Vermont cannot support H1, and we encourage you to reject it. Thank you. And I apologize, but I've got a doctor's appointment I've got to get to.
Thank you.
Yes, thank you for your time. We have Emily Ruff next on our list.
Good morning.
Good morning, how are you?
I'm great. Thank you for having me, Chair and members of the committee. Thanks for the opportunity to speak with you today. I echo the prior speakers' respect and gratitude for your receptivity and openness to comments of my own. My name is Emily Ruff. I'm a resident of Orange, Vermont. I'm a director of a nonprofit organization and also run a DCF licensed childcare facility. I'm a former select board chair and currently serve on a number of boards and committees throughout regional and local government. In our last legislative session in 2023 and 2024, I devoted dozens of hours to providing my input on House Bill H75, participating in public focus groups, submitting written testimony to legislators, including many of you on this committee last term, and testified like this before different committees. And today I'm here to express my opposition to H1. It's a bill that I believe will have negative consequences for public trust in our state government. I wasn't aware until Mr. O'Grady's testimony this morning that there was a new proposal or amendment, so I have not had a full chance to study those amendments, and my comments today are largely based on the original bill as it was introduced. The House and Senate ethics panel's requirement to consult with the Vermont Ethics Commission when handling complaints referred to them is both confidential and non-binding, and that consultation provides an essential layer of oversight and transparency that ensures that complaints are interpreted through an impartial lens. H1 would remove that safeguard, exempting the legislature from even asking for independent advice. The optics of this change alone are troubling to me, particularly in today's national climate, where public skepticism about government accountability is already widespread and growing. To remove this modest but important check on legislative ethics creates the perception, if not the reality, that lawmakers are insulating themselves from oversight. Last session, House Bill H75 went through a lengthy and arduous process to become law, including congressionally directed public input sessions prior to the development and subsequent passage of the bill. In those sessions that I attended and spoke, the public was overwhelmingly in favor of strengthening the ethics processes among officials of all three branches of state government, as well as local government. It's curious to me that there were 3 of H1 sponsors who voted yes on House Bill H75, one of whom was absent. Given the careful and thoughtful process that was used to pass H875 and improve government ethics in Vermont, I'm surprised that the same representatives who voted for that bill now feel the need just a few months later to reduce public safeguards. Moreover, I believe that there are process concerns with how H1 is being evaluated that warrant attention. For example, as a prior speaker shared, 3 of the sponsors of H1 currently serve on the House Ethics Panel themselves. And so from a public perspective, it appears that this bill is being rushed through committee without sufficient time for meaningful public scrutiny, bypassing taxpayer input. The constitutional arguments that are raised against the consultation requirement, specifically because it's non-binding, appear little more than pretext to avoid outside accountability. For legislative ethics panels to be asked to receive non-binding guidance from the Ethics Commission does not, from my lay perspective, seem to usurp your legislative authority, especially because it explicitly excludes the oversight of the core legislative function. Now, I'm not a legal professional or even a legal scholar, but I briefly did review Mr. O'Grady's slides from February 13th presentation and his testimony today, and it still sounds clear to me that there's a separation of power and that your legislative function is very clearly exempt. If anything, it seems to me that non-binding consultation from the commission by these panels only emboldens and validates your authority to the voting public. Right now, we're watching the erosion of checks and balances in our federal government every single day, and this bill on the state level seems to further dilute ethical oversight, and it gives the appearance of the players refereeing the game. Rushing this bill through without careful review and public input just reinforces those optics. It's a time when public is already really skeptical about the integrity of our institutions, and trust in government is at a historic low. Passing H1, especially rushing it through right now, threatens to deepen public mistrust and disillusionment in state government. We Vermonters expect and deserve transparency, fairness, and accountability from our elected officials. H875 worked really hard to move the state in the right direction, and removing independent, non-binding input on ethics matters just reverses that course of progress. I urge the committee to consider the long-term consequences of passing a bill like H1, further eroding confidence in state government, and I hope that instead you'll prioritize measures to strengthen transparency and public trust in your work. Thank you for your time and consideration.
Any questions for the witness? All right, thank you so much for your time and your input. All right, and then lastly, we have Ben Kingsley.
Morning. My name is Ben Kinsley. I'm the Executive Director of Campaign for Vermont. We are a statewide nonprofit advocacy organization representing everyday Vermonters, and we have a network of about a little over 20,000 people across the state. And we were really instrumental in starting this whole conversation back in 2013. We released a position paper entitled Achieving Accountability, and that report highlighted some of the failures of the state in terms of ethics oversight and enforcement, looking at a lot of the national organizations scoring, including the State Integrity Investigation, the Sunlight Foundation, that gave Vermont failing grades, quite honestly, for ethics, oversight, accountability, and transparency. In 2015, we launched a petition in favor of creating ethics policies in the state. We gained 500 signatures in 2 weeks. First 2 weeks, the petition launched. In 2016, we worked to build a coalition with the League of Women Voters, the Vermont chapter of the American Civil Liberties Union, the Vermont Public Interest Research Group, the Secretary of State, and a number of others in favor of passing ethics laws. In 2017, after 2 rounds of legislative testimony on proposals that have been put forward, we finally passed S8, which became Act 79, which was then signed into law by the governor on June 14th of 2017. And that law created the State Ethics Commission and laid the groundwork for statewide ethics reform. In 2022, we supported the Ethics Commission as they were getting their feet under them and proposed a statewide code of ethics, really looking at that as the next step in ethics legislation in Vermont. And at the time, we were still only one of 5 states with no statutory code of ethics. That bill was intended to fix that and eventually got signed into law as Act 102. Again, last year, we supported the Ethics Commission's effort to expand oversight in Act 171 and set the concept for a uniform basic set of expectations that Vermonters, can expect from the conduct of their public officials, regardless of which branch of government, regardless of which level of government, which included municipalities in that bill. And we really think that looking at the state of ethics in Vermont and the state of ethics legislation, Vermonters just want to know that their public officials are serving them, that that they have their best interests at heart. Ethics laws are a way of doing that, right? It gives people an outlet when they do have concerns, and we believe strongly that in having an independent voice like the commission, which really is separate from government. I think TJ said earlier that the structure of the commission is intentional. There is no gubernatorial appointee on that commission. That was intentional. We did that specifically to avoid that perception of an executive branch entity trying to insert themselves into legislative functions or judicial functions. We're looking at the long term when we made that recommendation, and it may need to evolve in the future as oversight authority evolves. But that was intentional, because if the governor was trying to exert control over the Ethics Commission in order to target a legislator, or vice versa, we would have an issue. We would be the first ones to step up and say that's not the way that's intended to be used. The Ethics Commission needs to be independent. It needs to provide advice, and in a perfect world, it would also provide oversight authority like 43 other states have. I understand that your lawyer has opinions about the separation of powers and what that means for Vermont, and quite frankly, those conversations have gone all the way back to 2015 when the first bill was introduced. In fact, your House clerk wrote the bill way back then. And we worked through a lot of those issues, even as far back as that, again in 2022, and then again last year as that bill worked its way through the legislature. These are all solvable problems. And you can do that by, and we think in a lot of ways you can do that by, increasing the investigatory powers of the commission and the consultation role of the commission. Obviously, when you get to core legislative functions, there's an exemption for that. When you get to the point of like, okay, there is a finding, and you now have to levy some sort of punishment, whether that's a fine or censorship. The legislature's role is to do that when it comes to legislators. The judicial oversight accountability mechanisms are probably in play for that as well. But there's ways of managing these things, and I think one of the things that came up earlier, there's been a lot of conversation about separation of powers, and that is a concept that basically every state constitution in the country has, because we more or less all copied the federal one. And there's another concept there too, which is checks and balances that we see show up in many of these state constitutions. And again, 43 other states have figured out how to give their ethics commissions enforcement powers over the legislature, over all 3 branches of government. We strongly believe that these are solvable things, and that we can move forward in a way that that meets Vermonters' expectations. So I will pause there for any questions.
Any questions for the witness?
Thanks so much for your time.
No, thank you for the
Thank
time.
you.
All right, committee. That was a lot to take in. As we started picking up some work on a few other things, we started to take a peek at the schedule for next week and see what discussion here. That was a lot of valuable input as we start to navigate how we're gonna approach this one. So with that, we do have this afternoon the joint governance meeting with our Senate colleagues on the ed conversations. And we do need to start getting the details for a budget recommendation in order for next week. So what I think I want to do here is just kind of stop with the formal testimony so we can start working on getting a couple of things teed up. Everybody's got some bill assignments for stuff that we're doing next week. We discussed that earlier. So start laying out witness lists and things like that. So we will go offline for now, but we will work up until 12 o'clock for the lunch hour. Representative,
When are we gonna discuss this?
that's what we're going to discuss on the agenda.
I have some things that I would like to share, but if now is not the time, I'm happy to
If
wait
you'd
until
like to
next
share
week.
now, please.
Okay, just while I'm thinking about it, I don't wanna push here, we have somewhere to go, but just after sitting here and marinating on, just taking some notes. It's ironic to me that we appear to have, that we're like, a conflict of interest is about the appearance of a conflict of interest, not just like an actual conflict of interest, right? So the irony here is that we're discussing whether or not it appears that there's a conflict of interest by us trying to remove ourselves as a body from the state code of ethics, the obligations, you know what I mean? Like, we're kind of
Taking our role away.
we're in this weird spot. And I mean, first of all, it seems to me like the little, I mean, I know it's not little, but like that one changing the word, I support Director Sibbert's suggestion that we change it to it's of the executive branch, because I feel like that really addresses an issue that is of the two conflicts here. That's the smaller one. I think that's a change that's easy, and it made me feel better after I heard TJ say that there are other states who do it that way, who have it as part of that branch, but it's an independent entity. It's not without precedent in other places, and that seems fine to me, and I think that we should think about that. I also, it just gives me pause to hear, I think being transparent and ethical is like the top of our list of things that we're doing here as a body and as people who are representing our communities, right? And it just feels like if we can maintain the strictest standard of ethical behavior and being held accountable for that, while at the same time respecting our state constitution, it seems like there are ways to do that. It also gives me pause though, just to hear legislative counsel say, well, there's no one really to enforce this anyway. And that even if we left it the way it was, who knows what would happen? I don't know, maybe it would go back to the Supreme Court, maybe it would just continue to be the way that it was. But it seems to me like we could and should leave it intact as much as possible. And if that just means removing that phrase 60 days, then fine, then we do that. If that's something that works as we discuss this further, and just say if the time period is the thing that's causing a problem, then just remove the time period and see what happens. Which I know see what happens seems a slapdash way to approach making a law, but if we don't know what's going to happen with the way it is now, remove the barriers and keep the spirit of it, and keep the commitment to being ethical and to being transparent and accountable to the public. And that is all I had to say.
Anything else for anyone?
Trying to.
Did you have something, Representative?
I'm just trying to go back, read the optional proposed amendment from Michael Grady. I just Now I'm trying to find it because I got so many pages open.
And just go back
Across
to
the
our
top.
committee webpage and click
Yeah.
on today's date and it'll pop right up under his name.
And we will have more time to discuss this. I appreciate having testimony today because as somebody who's new to this committee, I felt rather rushed just because I didn't have the context, didn't understand the players, didn't understand the language. And I still feel like even though this was dense testimony, that this is a really big topic and I want to make sure that we're being intentional and deliberate about it and not just rushing things through with haste because I wouldn't feel comfortable doing so. So I appreciate today and I would encourage us to continue to move with intention and not haste.
Mhm.
Especially because that's to do with ethics. Like, yeah. Let's be ethical.
All right, well, if there's no other opportunity for now.
Thank you for that, Jerry. I appreciate it.
Of course. Autumn, feel free to take us on. And we'll meet back downstairs at 1 PM, room 11 for the joint meeting with